to innovation challenges using their energy and ingenuity, curiosity, and creativity to steer a course towards a better future. Every April 26th, we celebrate World Intellectual Property Day to learn about the role that intellectual property rights play in encouraging innovation and creativity. World Intellectual Property 2023 recognizes the huge potential of females to find new and a better solution for IP that accelerates innovation and creativity. World IPR Day is an opportunity for young people to find out how IP rights can support their goals, help transform their ideas into reality, generate income, create jobs, and make a positive impact on the world around them. Friends, today we are living in the midst of information revolution. Intellectual property is the result of conversion of knowledge into a commercially exploitable potential. We have a lot more to learn about this very interesting field, but first, I would like to welcome our honorable guest. It is our extreme honor to have with us Honorable Head of the institution, Major General Rajendra Kumar in absentia, Dr. Professor Rakesh Singh Chauhan in absentia, and revered faculties. I cordially welcome all the students and all other dignitaries who have come to join this webinar. We all are indeed elated and honored by your presence on this auspicious day. Now, on the behalf of Amity Law School and Institutions Innovation Council, Amity University, Madhya Pradesh, I would like to welcome the speaker of the day, our very honorable guest, Dr. Victor Weber Tandon, who will enlighten us with his expertise knowledge of IPR. Sir is an academician turned law mechanical patent litigation at the firm. Prior to joining the firm, he taught as an assistant professor at a prominent National Law University of India. He is also a registered patent agent and an advocate. He has obtained his bachelor's degree in chemistry, followed by LLB from University of Delhi. Thereafter, he pursued his LLM from Indian Law Institute, New Delhi, specializing in IP law, where he secured the top rank in whole of his batch. He has done his PhD research as a junior research fellow of the Government of India, in which he compared the patent eligibility norms for pharma biotechnology innovations in India within EPC and in USA, with the aim of suggesting improvements in the Indian system. He has been a part of a team of lawyers involved in landmark judgments of Honorable High Court of Delhi, including those pertaining to confidentiality clubs in SEP litigation and the grant of first ever anti-suit junction in India in patent matters, as well as litigation pertaining to genus specie patents within the pharmaceutical and chemical patent space. Sir has also extensively worked with FRAN economic experts in context of our SEP litigation practice. He has also been involved in several mediation proceedings relating to patent disputes at High Court of Delhi. Now, I would like to invite Sir to lead the platform, and I will also request the audience to kindly drop their queries in the chat box. Sir will take the queries after the session ends if the time permits. Sir.
Yeah, thank you, Ankita. And thank you, Shubhangi. Am I audible?
Yes, sir. Yes, sir, you're audible.
Okay. So I'll just increase the volume of the system a bit. Okay, so I think we can start. Thank you for having me. And as I was just telling Shubhangi ji, I have a hard stop at around 11:55 because I have to log in somewhere else. So that Devanshu who is playing the PPT, because I can't see it on my screen. So you may start, Devanshu, or the student who is handling the presentation.
Yes, sir. Priyanshu, you can start the PPT.
Yeah. So the topic, artificial intelligence, patenting artificial intelligence. There are three ways of looking at it. And I was wondering, because I would have about 45 minutes to an hour, what is it exactly that I should focus on? And the three perspectives are that number one, you ask a question that how do you patent artificial intelligence, as if artificial intelligence, or rather I should say components of it, are the inventions, how do you go about obtaining patents over it or over parts of it? That's one way. The second is, just let me put this on silent. Sorry. The second is how artificial intelligence is going to impact the job of lawyers and as a subset of patent prosecution people, of patent attorneys or patent lawyers like me. And third aspect, which is perhaps very current, the US Supreme Court just on 24th, day before yesterday, denied a motion to hear an appeal on the same, is what if artificial intelligence is the inventor? So when I say artificial intelligence, what if this AI goes on to invent something? How do I patent that? Are the norms going to be different? And this third aspect is what I'm primarily going to focus on during most of this talk. The first thing that patenting artificial intelligence is basically a subset of patenting computer programs. The first aspect that you can see on your screens now. What if I want to patent artificial intelligence? Artificial intelligence is a bunch of algorithms to solve a particular problem which mimics human behavior, increasingly mimics human behavior. So we have settled on this. I'll just point that in the first 5-10 minutes. The second, how AI is going to impact the work of patent agents, patent attorneys, prosecution teams. That is also a subset of how artificial intelligence and the emergence of machines is going to largely impact how lawyers work or how any professional works in the new world. Third is a peculiar patent jurisprudence problem. What if artificial intelligence gains sentience and starts inventing, and therefore competing with human inventors? And this, to me, raises some really very interesting jurisprudential questions in context of justifications of patent rights. Now, this being the larger context, the three perspectives and the third one on which I'm going to focus, there are a couple of assumptions that I will proceed with, because I am going to delve on a slightly higher topic. I'm going with the first assumption that most of you do know something about patent law, so that I don't have to go into the very basics of it. Number one. And number two, also because I was told that most of you are going to be actually LLB students, I'll also assume that you have some degree of familiarity with regard to computer related inventions or software patents, because the very first topic, that's not something I'm going to delve on majorly. These are the two assumptions I will make because of time constraints and because of the kind of topic that I'm going to focus on. Now, should I proceed? This one thing, because in the physical world, I can readily see you people, see how you are reacting, can feel you. But on the virtual world, all I see is myself speaking into a computer and a big screen, which is showing me my own presentation. So I will keep asking this question. I have this irritating habit that can you hear me? And can you understand me? Because it's just you speaking and me speaking into a blank screen. Any of you can speak up. Am I audible? Am I clear?
Yes, sir, you're perfectly audible.
Yes, sir.
Okay, thanks. I'll keep asking these questions in between. Can I go to the next slide? Priyansh or Divyansh, whoever is handling. Yeah. So you can keep moving the slides based on how I am speaking. That talmel or jugalbandi you will have to achieve anyway. So the thing is, you can come. The thing is that whenever this new technologies emerge, and AI has been with us since at least the 1950s, whenever these new technologies emerge, one question that arises, and this reminds me of the question that I asked in my PhD, what is so new about biotechnology? We have been having it since thousands of decades. We have been using fermentation and all those things. We are having machines. We are using machines. This Zoom platform is a computer program. The laptop I'm speaking into is a machine. You all do your drafting on a machine. You have your Microsoft Word and your Gmail accounts, which can do some predictive assistance to you, what you're going to type next in the line. What is so special about AI? What is it that has changed today? Their machines have always been there. Machines have always raised questions that they will eat into jobs. And as you can see, in at least the pharmaceutical space, a lot of new drugs are increasingly being designed using computer programs, computer softwares, the tools of ICT and combinatorial chemistry. So, and you have data analysis, processing of data happening through machines. What is it about AI that makes us all so very uncomfortable? And that aspect is how the fact that today we are evolving, developing programs with an increasing capacity to mimic human behavior. And which brings us to a very fundamental question. What is it to be human? This very philosophical question, what it means to be a natural person. Does the fact that I'm able to recognize faces, that alone makes me human, because today AI is doing that. They are face recognition softwares. You can move to the next slide. Does solving simple mathematical equations, 2 + 2, 3 + 4, like the CAPTCHA code, sometimes they ask me to calculate or subtract or multiply. Does that make me human? Well, you have advanced softwares who are doing these things. Does the fact that interacting on a customer care call with somebody make me human? You have chatbots who are doing that, who have taken over customer service operations. So increasingly, you have these softwares with ability to mimic human behavior, to act like humans. So what makes me human? Is it my consciousness? Is it my empathy, my love? Because today, as understanding of the sciences, machines probably lack consciousness or the ability to have a completely independent thought. Artificial intelligence, whether you take the example of ChatGPT or facial recognition, chatbots, whatever you're seeing on the screen, they are based on the kind of inputs you feed into them. And in computer programming parlance, there is something known as GIGO, garbage in, garbage out. So if the sophistication of my input is going to determine the kind of results I'm going to get out of my artificial intelligence machines or out of my softwares. And with this brief background of what artificial intelligence is, till date, to my understanding from whatever limited literature I have read on this aspect, artificial intelligence is not capable of an independent self-learning. It has to be fed data. It has to have as good as the databases for it. On the basis of that, it might be able to make permutations and combinations. But if you call for a completely new innovation, a completely new sound, it will not be able to generate that. Not at the kind of sophistication we have achieved today at a commercial scale. So with this understanding, we come to this. And another thing that I do during these presentations, you can read the presentations, the slides, but what I speak is basically an explanation of what is written on the slide. So I won't be reading the slides themselves. Otherwise, that will make me a machine. So maybe this aspect, that having given you a slide, I am still able to not rely on it fully, but able to generate an independent thought which hovers around that what is written in the slide, to give you a larger perspective. You can read and then also listen to what I'm trying to make you understand. Perhaps if I could put it in simplistic terms, AI may not be able to do this today with the same level of sophistication. So perhaps there might be experts in of the computer field. I'm not an expert of computers or AI who might be able to counter me. But this is an understanding that sentience, independent of the kind of data which is fed into them, is perhaps absent in today's AI. So anyhow, can we have the next slide, please? Yeah. So basically, human beings when we talk about patenting AI or patents by inventions created by AI or using AI, we have to understand the kind of role human beings still play at various stages, whether it is a stage of creating, writing down those AI algorithms, and algorithms are nothing but step-by-step procedures or to solve a particular problem. Like I have to take something out from the fridge, go to the fridge, open the fridge, take out the dal or take out the chocolate and close the fridge, peel off the layer of the chocolate, eat it. So step-by-step way procedure of solving a problem. So creating algorithms or programs which constitute your AI software, designing AI to suit a particular purpose, selecting data, giving inputs to AI, training AI, so that it can, after it has seen thousands and 1,500 or 2,000 images, or after it has been fed my voice or the usual questions I ask from Siri, or recognizing when Victor Tandon says, "Hey Siri." So giving it that kind of training, writing those programs, selecting the quality of data or images. One of the favorite capture things, identify in what all images a car is present, which is something that human beings can do, but I can perhaps train a AI to identify different parts of cars, different colors of cars, and perhaps solve that captcha also. Or prompting artificial intelligence, designing it to solve a particular problem. And an example of this comes from my childhood when I was much younger. In 1997, if you remember, there was at that time, one of the strongest competitors of Vishwanathan Anand was one chess player from Russia named Garry Kasparov. And there was an IBM Deep Blue computer which was able to consistently beat Garry Kasparov. And this was considered to be a triumph of machines, man versus machine or man versus artificial intelligence. But there was just one point that researchers had said at that stage, that Deep Blue was able to defeat Garry Kasparov because it was trained to analyze each and every move that Garry Kasparov had ever played, that people who had won against Garry Kasparov had ever played. It was designed for that very specific purpose. Outside of defeating Garry Kasparov in a game of chess, or any grandmaster for that matter, it could have failed in performing other simple computer tasks. So you are having specificity to do certain things by a machine. Like a car, a car is not an AI machine. A simple car is used for driving on the roads. I can't use the same car for taking me to space. I'll have to use a rocket. So specificity of what kind of problems that particular artificial intelligence is designed to solve. Unless increasingly, the last line, you reach a stage where artificial intelligence has self-learning and sentient capabilities, where it will not require human beings, it will teach itself to do n number of other tasks. Today, our level of research is not there, as per my understanding. So, can we have the next slide, please? Yeah. And so this was a very brief context of what artificial intelligence is all about and highlighting what we are going to do today. Now, as far as the very first question is concerned, some of these things, as I said, you might already, at least the students of patent law might already be aware of. Patenting artificial intelligence, or which is a subset of patenting software itself. I'm not going to dwell too much on this part. Suffice to say that you all know that we have I always tell people we have 5 different criteria for determining whether any particular invention is eligible for patent grant or not. One of them is novelty, one of them is inventive step, and industrial applicability. The TRIOCA, which you usually designate as patentability parameters. But behind that, or equally importantly, you also have an eligibility parameter, Section 3 and Section 4 of the Patents Act. And Section 3 says, what are not inventions? So even if you develop something which is covered under Section 3, I am not going to consider them as inventions. So having novelty, inventive step, and industrial applicability in that sense is going to be futile. And lastly, something known as a written description requirement or sufficiency of disclosure. So, and I can give you one example. I understand that some of you perhaps might not be aware of patent law, but just one example I give to all people who, all new people who enter into this domain. No, you can go back to the previous slide actually, whoever is managing it. You can go back to the, yeah. Imagine there is a person who is willing to sit in a particular exam, and the minimum age of that exam is that you have to be 18 years old. So if you are 18 years old, you have to write an answer sheet and you will be judged on whether your answers are correct or not. Now, there is a person who's a genius and who is 16 years old and writes an answer sheet. Your answer sheet is your written description or disclosure, what you are disclosing as your invention to the patent office. The quality of the answer sheet, whether it has novelty, inventive step, industrial applicability, is going to determine your ability, patent ability. But the fact that you are 16 years old and not 18 makes you ineligible. So eligibility, whether you are considered an invention or you are considered fit to sit for an exam. Ability, whether you have novelty, inventive step, industrial capability, whether you have written a suitable answer. And how do I check all these things? From the documents you are submitting, the written description or disclosure. So these 5 things make you the usual test of patent grants, and they're applicable to all inventions, which is what was written on the next slide. Applicable to all inventions, including to computer related inventions, including to any patenting of artificial intelligence. But more importantly, there is one particular provision which goes to the root of how to evaluate patentability, patent eligibility of computer related inventions, computer programs, artificial intelligence, which is section 3K on your screens. Our act says that a mathematical or business method or a computer program per se or algorithms are not patent eligible subject matter. But so if you are giving me a journal software which is workable on any machine, I'm not going to grant you a patent. That is the domain of copyright law. If you are giving me a computer, an algorithm, a series of steps to solve a particular problem or achieve a solution, a business method, I'm not going to give you patents over it, because that's just like a blueprint. An algorithm is nothing more than a blueprint of solving a problem. If you write a program based on that, 2 + 2 is equal to 4, it can be run on any machine. Calculators run on it. You have calculators on all kinds of desktops, all kinds of operating softwares. A general computer program, which is perhaps runnable on every machine, I am considering it only as a computer program per se, nothing else. No technical effect independently in conjugation with the hardware. I'm not going to give you a computer a patent over it. This is what the law is. And there has been a judgment of the Delhi High Court, single judge of Delhi High Court on 12 December 2019. The criteria, when does a computer program per se, a computer program by itself, makes the jump and becomes something more than a computer program per se, and therefore becomes eligible for patent. A computer program which can demonstrate a particular technical effect or a technical contribution in conjugation with a hardware element, a means for producing, or a computer program as a means for adapted to produce a particular function in a machine in conjugation with hardware devices, that perhaps can take you from the domain of ineligibility to the domain of eligible computer programs for which patents can be given. And these are the same metrics which any artificial intelligence software will have to fulfill to be worthy of a patent. So I think we can quickly go to the next slides. This we have already discussed, and we can go to the next slide. Yeah, so this is basically what I had been explaining. These are guidelines for examination of computer related inventions 2017. A word of caution, guidelines are not law. These are guidelines which the examination division of the Indian Patent Office has evolved for internally for dealing with computer related inventions, applications for patents which are related to computer softwares. How the examiners are going is a guide for them. Tomorrow, if a High Court or a Supreme Court says a different thing, these guidelines will collapse. They don't have the force of law. but you can read some of them. The law students will readily understand it. The form does not matter. The nomenclature does not matter. The substance of the document or the substance of the claim matters. Number one. Number two, uh, most of these computer program softwares, they are written as method claims. There are two kinds of claims, product claims, process claims. So they are written as process claims or method claims, system claims, which indicate the flow chart or process, how to go by step solving the problems. And they are often written as means plus functions claims, which I was just alluding to a while back. Means, in this case, the computer program adapted to perform a particular function. And if all you have to perform a function, say addition, is just a general software which you can run on any machine, which does not conjugate or work with particular hardware elements of your device, then you don't have a patent eligible invention. This is the current level of understanding. And equally, just as a side note to this, before I go to the major topic, today increasingly, there are voices against IP also. You have open access, copy left movements, open access movements. In fact, there are feminist critiques of copyright law. I was just reading about it a while back. And likewise, in the patent field, you have open AI or something known as the anti-commons effect. What it basically entails it that if you allow patents over too much of basic technologies, follow-on innovation becomes that much difficult, because anybody who is standing down the stream and wants to go a step ahead, engage in follow-on innovation, that person will have to negotiate with everybody who came behind him or her. So that will increase my cost of innovation. So the argument is made that basic technologies should be kept open for all. There should not be too many patents, too many IPRs over foundational technologies. Imagine if I patent, say, a mathematical equation or 2 plus 2 is equal to 4. Anybody who's doing 2 plus 2 plus 2 is equal to 6 will have to take a patent from me, or will have to take a license from me. So this is by and large what happens. What are an overview, I would say, of patenting computer softwares or patenting artificial intelligence. Now, this was the first perspective that I spoke about. The second is how artificial intelligence aids the task of patent agents, aids the task of patent attorneys, and is it going to replace us? I hope not. I don't want to be jobless or without work. But at today's level of understanding that artificial intelligence has, we all use it. You can go to the next slide, Priyansh. Yeah. So, like, we have a prosecution team here which uses this for prior art search. So if I want to see whether my patent is novel or inventive, in very simplistic language, I have to see that something similar to this or something identical to my patent has not been done by anybody ever before. I'm not going into the nuances of the respective tests. That's not my objective for today. But suffice to say that I have to see that my invention, you can see my hands, my invention is novel. It has not been done before, prior art. And my invention is inventive in the sense that it achieves a technical advance. If you see on your screens the movement of my hand, this is prior art. This is my novel invention. And it achieves a technical advance over existing knowledge, which is not fathomable to a person skilled in the art. So these are the two test novelty inventive steps. And so I have to see what is prior art. You can go back to that slide. Yeah. So for these prior art searches, now anything, any document which is prior published, which is prior from before the date of filing of my patent application, anything which is prior published, prior used, prior known, or prior claim can be prior art. How do I see? There could be something in German language, something in Korean language, something in English language. There could be a book, a treatise, an article, a granted patent, lapsed patent in Africa, in Europe, in China, in Pakistan. I don't know all these things as a human inventor or a human patent agent. So we have search engines, and increasingly these things are being automated. Artificial intelligence is aiding us, because even if it is a Korean language text, German language text, I just have to key in a few words like you Google search Victor Webb of Tandon. So we'll get some data about Victor Webb of Tandon. Then you make it better. Dr. Victor Webb of Tandon, IPR, Sai Krishna and Associates. It will become more specific to this Victor Webb of Tandon. There might be 100 other Victor Webb of Tandons. So increasingly, the kind of search strings we put, that is being automated. Artificial intelligence is taking care of that, and it is giving us better results, faster results. A few years back, somebody who had to make a landscape report, the kind of patents which are granted in a particular field of technology would take probably a month. A prior art search report would take probably a week, a lot of man hours. AI doesn't sleep. If I keep my computer on, it can just keep working, it will sleep. So that 1 month landscape report, it can do it in a matter of week or hours even, depending upon the kind of software we are using, and they're very expensive. There's one IBM Watson, I think the annual subscription is in lakhs, 5 lakh or 20 lakhs, if I'm not mistaken. So anyway, this is the second aspect. All of these topics are perhaps topics which can take 1 full day or perhaps a couple of hours. Now, this was the second aspect. Now I come to the meat of it, and we luckily have time. The third aspect, what if AI is considered as an inventor? Can we go to the next slide? Priyansh. Yeah. So this is a question that has been bugging us, has been at the forefront since at least 2019. Now, if you remember, initially, the genesis of all IP laws has been that there is at the center a human creator, a human innovator, a human artist, copyright, patents, whatever be the field. And that human creator or innovator has to be incentivized to produce knowledge goods, which will then lead to the progress of society. And this human creator has a personality. My personality is what I create. It becomes a part of me. My creations, my inventions, my books, my novels, my photographs, the kind of movies I make. A very, very easy example to understand is perhaps Anurag Kashyap, who makes Gangs of Wasipur, and Karan Johar, who makes Kuch Kuch Hota Hai. So the kind of art I create, the kind of innovations I create, are all extensions of my personality, pieces of me. And today, there are two questions. There was a monkey copyright case where a baboon or some monkey took a photograph. And whether animals, non-humans can be owners of copyright. And in the field of patents, whether artificial intelligence, machine intelligence, which has to mimic human beings increasingly, become more and more human, recognize faces, solve problems, do landscape reports. Can this be an inventor? Can a machine? So far, we have been inventing machines. We have been inventing every technological tool that you can see. But can a machine invent something? Can a machine be an inventor? It is a question of fact. It is a question of law. And within patent laws, you have to ask, do I designate machine as an inventor? Does the present patent regime allow for it or not? And this is a question which has bugged or which has been asked in different jurisdictions, as you can see on your screens. And one very important question is, irrespective of whether artificial intelligence is the inventor or not, or has been taking part in inventing something or not, there is an invention, say this pen. Will it make a material difference whether an AI is the inventor of this pen or whether a human being is the inventor of this pen? Does it make any difference at all? Should we discriminate between inventions because basis the fact that this invention, this phone, was made by a human being, or it was made by or with the assistance of an artificial intelligence or any machine? Should that kind of discrimination be there at all? So these are the kind of questions which have been attempted to be answered by different jurisdictions: USA, Germany, Australia, UK, and India. I will take you through an overview of all and discuss the commonality of questions, which is somewhere in the last few slides of mine. one thing, only South Africa so far is the only country which has recognized that an artificial intelligence can be an inventor. It can be noted as an inventor in a patent application. South African's IP office has said that. The funny part is that South Africa does not conduct a substantive formalistic examination of patent applications like other jurisdictions do. So it's as good as not having a reasoning behind it. You file an application, AI might be the inventor, you will get a patent. So that's about South Africa. You can actually move to the next slide now, Priyansh. Thanks. Yeah, Priyanshu. Before I start with this, am I audible, clear? Are you guys able to follow? I hope I'm not going too fast, or I hope it's not bouncing on the top of your heads.
Yes, sir, you're clear.
Okay. My colleague over here is working in the office, so he's smiling. That reminds me actually that one distinct advantage that any kind of artificial intelligence or any machine has over human beings, artificial intelligence wouldn't get bored and wouldn't sleep. And even if you are getting bored or if you're feeling sleepish by whatever mumbo jumbo I'm speaking, I can't know, because see the fun of technology. I speak into a blank screen and all I can see is myself in this small corner. I can't see any of you. And sometimes this Priyanshu's name keeps popping up from my Zoom. Priyanshu is doing this, Priyanshu is doing that. And we have a Priyanshu in our office also, Priyansh. So anyway, coming back to this, pre-COVID world was better. Maybe I could have seen you all in person. Anyhow, USA, this gentleman, one thing you would ask me that, sir, Victor, you have been saying that artificial intelligence lacks sentience, lacks imagination, lacks creativity as of current level of development of technology. So how can this artificial intelligence develop something? There are two parts to it. This was a particular machine called DABUS, as you can see on the purple highlights. DABUS, device for autonomous bootstrapping of unified science. A very funny name, DABUS. I don't know if it can conflict with the trademark DABUS. Anyway, so device for autonomous bootstrapping of unified science. This was a machine which was particularly designed for throwing out new combinations of inventive things, inventions, perhaps based on the database that it had, number one. And it is a source code. It's a collection of source code, a programming and a software program. If this is how Stephen Thaler defined this, DABUS is a collection of source code of software program. If I go by this definition, the very admission by Stephen Thaler that this is what DABUS is, and Stephen Thaler is the main scientist to develop this software, artificial intelligence, at least this DABUS itself cannot be patented, because it is a software program per se, computer program per se, just a source code. The next step is, what if this DABUS invents something? And as some of the courts noticed that Mr. Thaler filed these applications more for publicity, because at 2019, 2020, or even today, we do not know for sure whether artificial intelligence can actually invent something. Stephen Thaler says, Mr. Thaler, Dr. Thaler says it can. We don't know for sure. Scientific evidence is less. What was the involvement of Mr. Thaler? At how many stages Dr. Stephen Thaler was involved? How did he prompt? How did he go about it? We wouldn't know. But what actually Dr. Stephen Thaler, the applicant, has done is that he has raised some important questions, which today may be philosophical, theoretical, but tomorrow, maybe 5 years, 10 years down the line, we'll all have to face, and which require attention perhaps of the legislatures worldwide in all jurisdictions. So what happened was, Stephen Thaler, this Dr. Stephen Thaler, created DABUS, a set of codes, artificial intelligence machine for generating or assisting in generation of inventions. And then he filed a PCT application saying, number one, the inventor is DABUS or artificial intelligence. All inventions in those PCT applications, whatever applications and inventions have been applied for, they're all created by or invented by DABUS AI, number one. Number two, the artificial intelligence executed an assignment deed and assigned all rights in those inventions to Miss Dr. Stephen Thaler, thus enabling Dr. Stephen Thaler to sign documents and actually file the patent application as applicant. Because I don't see a computer walking into a patent office and saying, oh, look, I'm the applicant. That this couldn't do. So they needed a human thing. Just like, in companies act through its directors, or firms act through the partners act for the firm. So they are the ones who are the face of it, the human face of it. So these are the two things he did. And then he came into different national jurisdictions. One of them was USA. And the case you can see on your screen, Stephen Thaler versus Catherine Vidal, who happened to be the director of USPTO. US Court of Appeals for the Federal Circuit is one of the highest court, just below the Supreme Court, for dealing with patent cases in USA. And the question was, can a machine or artificial intelligence qualify as inventor? And you can have the list of the patent applications which were filed. Dabas was listed as an inventor, and the assignment of all rights was in favor of Dr. Thaler, the applicant. Now, can we have the next slide, please? Yeah. Most of the courts, USA, UK, Australia, Germany, and this question is still pending in India, have said, what does the law say? Courts have not stepped into the shoes of legislature. Courts have not stepped into the shoes of the legislature. They have said, we are going, it's a rather, if you students or jurisprudence will recall, you will have strains of positivist interpretation, the law as it is, and not natural interpretation, the law as it should be or as it ought to be. So US Supreme Court, other court, is US Court of Appeals of Federal Circuit, it asked the question, what does the patent law say? And luckily, section 100F of the US Patents Act 1952 is denominated as 35 US Code. Section 100F defines inventor as individual, or if it is a joint invention, the individuals who invented or discovered the subject matter of the invention. And basis the jurisprudence which had been evolved in US Court of Appeals for Federal Circuit decided that only a natural person, a human being, can be inventor or co-inventor under US patent system. So it rejected the application made by Stephen Thaler with Dabas as inventor. And this, as I said in the beginning, on 24th April 2023, just day before yesterday, the US Supreme Court refused to intervene in this. So this holds as the final position in US. Can we quickly have the next slide? I'll come to the philosophical debates in the last slide. I'll just encapsulate what has happened in different jurisdictions. Can we have the UK slide? Yeah. So UK, Stephen Thaler versus the Comptroller General of Patents, Trademarks and Designs. You have the citations and the date of the order. By 2:1 majority, UK said an artificial intelligence, or Dabas in this case, cannot be an inventor. Machines are not persons. They are not inventors within the meaning of UK laws. And therefore, Dr. Thaler could not have applied for patents, given the premise that in all of his patent applications, the inventor is an artificial intelligence. Can we have the next slide? Germany. You can read the slides. I'll just encapsulate what it basically says. The DPMA, German Patent and Trademark Office, rejected the application of Dr. Thaler again because it was non-human. Then the Federal Patent Court, the BPAT-G of Germany, said that, and this is something very interesting, that underlined observation. It is the applicant's conviction. It is the applicant, which is Dr. Stephen Thaler, whose view is that it was not him, but the artificial intelligence who invented the invention. Now, this is a legal fact. It's not something factual. Nobody is going to decide. Nobody truly knows what happened. This is between man and machine. If Dr. Stephen Thaler says, I did not invent, my laptop invented, fine. Otherwise, I could have simply said I invented. So this is one very important, pertinent observation. Can we quickly have the next slide? And they said it's up to Dr. Thaler, how he wants to say. It could have been a very simple matter if Dr. Thaler had said that I invented. After all, I do use machines for so many things. As I said in the beginning, we use ICT, combinatorial chemistry. We design pharmaceutical drugs on heavy-duty computer hardwares, computers. We don't say that the hardware invented machine. I don't. I type my. It's a very simple example. I type my assignment on MS Word. I don't say MS Word wrote my assignment. I say I wrote the assignment. So we don't know how much the interaction was there. That's between Dr. Thaler and his AI. But that is what the German court said. So, and then they said under German laws, the so far existing German jurisprudence, the inventor has to be a natural person. AI cannot be an inventor or a co-inventor. And we are not discriminating. This is something important, the one which is in purple, that exclusion of AI and as an inventor does not lead to a restriction of patentability or to any kind of economic disadvantage. You could have easily come and said that an inventor is Dr. Thaler. We would have given you the patent. This is an independent assessment from saying your invention is bad or not patent worthy. The only problem we have as of now is that the invention has been made by AI. That is an inventor. That cannot be allowed under existing laws. But it found out a solution. Ultimately, there was a to and fro, like the negotiations are there. So Dr. Thaler gave some number of options to the court. And ultimately he said that I be permitted to write that Dr. Stephen Thaler, PhD, who prompted the artificial intelligence DABUS to create the invention. And the German court said, federal court said, this is fine. At least there is human involvement. Human being, it is a deeming thing. It appears as if the human asked, it's as good as saying that Victor prompted MS PPT to create this presentation. So I am, Dr. Stephen Thaler is the deemed inventor. Can we have the next slide? And again, Australia, the same thing. I will not read the slides. Commissioner of Patents versus Thaler, the Federal Court of Australia in appeal overruled a single judge decision and said that inventor has to be a natural person. You cannot have inventor as AI. AI cannot be an inventor. And another important thing, how can somebody which is not recognized as having a legal identity give assignment of rights? Because all along, Dr. Stephen Thaler's argument was that AI has assigned all rights in the invention to me, and therefore I am the applicant. Inventor is AI. How can something which has no legal identity assign rights? A human being can assign rights, but a machine, AI assigning rights is unheard of. Next slide. Actually, we can skip the next slide. I'll explain that myself. You can skip this. Come to India. Skip. Come, go. Yeah. Now, in India, can we go to the next slide first and then come back to this? Okay, not this one also. The next, very next one. Now, Stephen Thaler came to India also. That application number 2020-170-190-68. It is still pending before the Indian Patent Office. And FER is the first examination report. The Indian Patent Office examines all applications, just like your teacher examines your answer sheets before granting a patent or before granting you a degree. So it said that there are a number of problems with the invention. It lacks novelty, lacks inventive step. But more importantly, it says that DABUS or artificial intelligence is not a person as under the provisions of the Patents Act. And there has been a pre-grant opposition also filed by Dr. Kalyan Kankala. He's the managing partner of Banana IP, a Bangalore-based IP firm. Does some wonderful research and has written a very good book on patent law in India, 2010 old edition now. So pre-grant opposition was filed by him. And this application, including the decision on the pre-grant opposition, is currently pending. So we don't know how the Patent Office of India is going to decide. But now you can go back to the last two slides. What does the law say? Priyanshu, can you, yeah, the slide before this. Section 6 of our Patents Act, you can see on the screens. It says that there are three categories of people who can apply for patents. One is the true and first, no, the previous slide, section 6. Any person who claims to be the true and first inventor, any assignee of the true and first inventor, and any legal representative of a deceased person where such deceased person immediately before death was entitled to file for a patent. Three categories of people, section 6. Now, there are clues. Person. What does a person mean? And number two, legal representative of a deceased person. Can artificial intelligence or a machine ever die? Can they be called a deceased person? So contextually, section 6 is giving you the hint that that person can only be a natural person. So a person who is a true and first inventor has to be assignee, can be a company, can be an organization, can be a firm. A firm can be an applicant, a company can be an applicant. But the true and first inventor who assigns first or who dies and the legal representative comes in has to be a natural person. And now what is a person? What does the Patent Act say? Section 21S, not very helpful, simply says person means the government. Then section 21Y says true and first inventor. True and first inventor does not include the importer of inventions. Again, not very helpful. Come to the next slide. Now, section 10.6, these are some of the formal requirements. It says that you have to file a declaration by the true and first inventor. The form is form 5. The rule is rule 13.6 of the patent rules 2003, as amended from time to time. Declaration as to inventorship has to bear the signature, name, address, nationality of the inventor. Again, a clue that in perhaps the person has to be a natural person. And then person, you cannot see anything from the Patents Act, not very helpful, section 21S. So we look at the Journal Clauses Act. Section 3.42, it says simply again, person shall include a company or association or body of individuals, whether incorporated or not. This is our idea of a person from jurisprudence. Persons can be a natural person, can be a juristic person. By a deemed fiction, law may ascribe personality to certain things, a company, but has to act through directors, human beings, a partnership firm, or a natural person like you and most of the listeners. I hope AI is not listening to us. So, and there has been this old judgment, 1960 of Karnataka High Court Division Bench. It says a firm, this is an important clue. A firm cannot be said to have the capacity to invent. Even if I think that company or firm, they are juristic persons, they do not have the capacity to invent. It cannot be called an inventor, although there may be no objection to it being registered as patentee. Ownership is different from inventorship. A company can own a patent. A university can own a patent. As a research professor, I used Amity's laboratories and invented something, and Amity University is putting the bill of filing for the patent application, paying all the money. Amity University will own the patent, but I, the human being, will be the inventor. But a machine, university cannot be the inventor. Firm cannot be the inventor. Company, last line, corporation cannot be the sole applicant claiming to be the inventor. So corporation, firm, university, we do not see them, do not envisage them as inventors. So if we do not even envisage them as an inventor, that's an important clue. There is no decision so far from any Indian court or the controller's office. This can be an important clue that artificial intelligence at our current level of understanding ought not to be considered as inventor because it is not a natural person. Now, this is an overview of what different courts have done. Now, what are the ideas which emanate? I still have about 5 minutes, so I will quickly encapsulate those ideas. And can we go to the next slide? Thoda sa jaldi. And this we can skip. Yeah, jurisprudential dilemma. These are the questions which have been asked, which are being asked, which have been tackled or avoided by some of the courts, some of the IP offices. Can AI have, to be a person, I need to have certain rights and duties. I need to have a personality. Even if I'm a juristic person, law will ascribe a personality to me. Can artificial intelligence at its current level of understanding have rights, have duties? Will it be entrusted to act responsibly? Can it have personality? Does artificial intelligence fit into the existing justifications for patent law? And this is where it intrigues me. It is usually said that all IPRs are an incentive to innovate. A machine, a computer program, and artificial intelligence, which has been designed with the objective of churning out particular result, of churning out new and new inventions, or of churning out data sets, which never sleeps unless I switch it off, at least today. I can switch them off. I don't know, tomorrow there might be machines controlling us, but anyway, I think I should stop watching Terminator. Anyhow, so does a machine need an incentive to act, to innovate? So how this so-called natural rights justification, as I said in the beginning, IPRs are an extension of my personality. IPRs are an incentive to innovate. We will have more innovation in the society. This applies to a human being. Human beings need reward. You get good grades, your father will get you a bike. Or, does a machine need a reward? Does an artificial intelligence need a reward? Can you ascribe, can a machine have labor rights? Will my sweat and bro, the test of sweat and bro, my labor, extension of my labor, can we have these norms applicable to machines? If parliament says so, we will have to agree. But logically, at our current levels of jurisprudential understanding, can this be done? I don't know. Next slide, quickly. And I think the third or fourth line. There are norms of patent law. These are questions I leave to you to ponder. Maybe 5 years down the line, we will need answers to these questions. We have a test of persons skilled in the art for assessing inventive step. What happens to this test, this concept of that you have the reasonable man in tort law? What happens to this reasonable man? What happens to a person skilled in the art of patent law? Can an artificial intelligence be a person skilled in the art in context of an invention created by AI? So it will be inventor AI versus person skilled in the art AI. Who will win? What happens to the matrix of this common law designed tests of patent law? How are our understanding of this whole jurisprudence of whole patent law going to change? And then one fundamental question, if we really want to benefit humanity by creating more technological innovations, does it really matter at the very root of it? A question which was posed to Stephen Thaler, who was so obstinate that he wanted to list AI as the inventor everywhere. Does it really matter whether the invention has been made by AI or a human being, as long as humanity benefits? We don't know. And then there are resolutions. By the way, there's a parliamentary standing committee report. You can quickly go to the last slide. The previous slide, sorry. No, not the last slide, the previous slide, the one before this. Go back, this one. Report number 161. Report number 161 on review of IPR regimes in India. Parliamentary Standing Committee, Rajya Sabha, they tabled this report 23rd July 2021, and they said they need a separate category of rights for AI and AI-related inventions and solutions. I don't know what kind of rights our great legislators are going to ascribe to AI. And can you have rights without duties? What will happen? I'll leave those questions to you. And just go to the second last slide now, quickly. My time is also up. There is a resolution on inventorship of inventions made using AI, which was filed by an association of patent attorneys, patent professionals, World Congress 2020, 14th October 2020. You can Google it and you can find the resolution. It says that an inventor, the definition of inventor is somebody who has made an intellectual contribution to the invention. And it also says that AI alone cannot be an inventor, but at the same time, there should not be any discrimination between something which has completely human inventors and something which has been made or invented using AI or by AI. Don't discriminate. Let inventions come forward. Let them benefit humanity. But there has to be some intellectual contribution, some human element involved. This was a resolution 2020, does not really have a binding precedent, except that it makes for a good article and all. Yeah, so that's about it. I think, I think I should stop now. I actually exceeded my own time. So we can perhaps give 2 to 3 minutes, just 2 or 3 quick questions. And can you now stop this PPT? Because I really want to see at least the names of the students now. And are you alive, all of you? Oh, yeah, so great. Guys, you can speak.
Yes, sir. You're audible.
Yes, sir.
Yeah.
Thank you so much, sir. Your expertise on the topic of intellectual property rights was evidently clear, and your insights provided a new perspective, and that generated thought-provoking discussions among our audience, I'm sure. I hope we could have an opportunity to discuss this topic in depth with you in upcoming sessions. Till then, we had a little question, if you could answer the same. So,
Anji.
if we are giving patent protection, is it enough to incorporate AI-generated inventions in current legal system, or should we consider, should consideration be given to sui generis system of IP rights for such inventions in order to adjust inventions of AI in specific?
See, that's an age-old question. The parliamentary committee, to my understanding, actually suggested that there should be a separate bunch of rights, a separate, what should I say, medium or sui generis system, as you say, for anything which is developed by AI, whether it is in the perspective of inventions or whether novels or songs. But, and this has been an age-old question, as I said, whenever a new technology comes, like when biotechnology came, the question was, can an old law, which has its roots in 16th century or 1600s in Europe, patent law or copyright law from the Act of Anne and Statute of Monopolies in UK and Italy and all those things. Can these new old laws adjust to new regimes, new inventions, new technologies? And this also is no different. If you ask me, my perspective is that don't muddle things more. If to me, if your final agenda is just to benefit humanity, current patent law is enough, whether you designate AI as an inventor or not. As I said, we've always been using machines. Stephen Thaler probably wanted to become famous. Today, a machine by itself does not have the sentience or self-awareness to invent something radical. It can throw different combinations. It can have assistance by human beings. Maybe 5 years, 10 years, or whatever time down the line, if they do start making intelligent machines with intelligence that rivals that of human beings or super intelligent machines, maybe things would differ. Our understanding would differ. But today, instead of going for new laws and creating more trouble, let's adjust them within current rubrics. And if it is benefiting humanity, it does not really matter. For all that is there, the German code, the Federal Patent Code of Germany, it suggested perhaps that deemed fiction, that a human being prompted artificial intelligence to make this invention. That can be a solution.
Thank you so much, sir. Lastly, I would like to conclude this seminar by calling upon Assistant Professor Shubhangi Gupta to kindly give the vote of thanks. Ma'am, please take over.
Yes. Thank you so much, sir, for accepting our kind invitation. It was really indeed a very good session. You lucidly cover all the aspects in relation to AI and patents, mainly broadly, I could say all the aspects, like how the patentability of the AI, then whether the AI can be considered as the inventor of patents over the technology, and how the AI could help the attorneys. So indeed, the larger perspective, I would say the larger spectrum has been covered by you, and it was really good. I think the students of Amity would have learned a lot in this particular aspect. And we really hope that next time we could have you in person. It was indeed a pleasure to hear you, sir. Thank you so much, sir.
Thank you. So can I leave?
Yes, sir. Yes, sir. Sure.
Join
Yes.
somewhere else.
Sir, completely, I can understand. Thank you, sir.
I'll just log out. Thank you, guys. Thank you for
Thank
having
you so
me.
much, sir.
Thank you.
Thank you,
God bless
sir.
you all. Thank you.
Okay, students, you can leave. We are ending the session.